Welcome to CARICOMP Insider, where high-tech facial recognition meets real-world intelligence. A European grocery chain got hit with a major fine for running facial recognition on shoppers without meeting biometric data rules. That penalty didn't happen under some future law. It happened under the framework the EU is now expanding, and it's about to change how biometric evidence works everywhere. If you're an investigator, an analyst, or anyone who touches facial comparison tools, this matters right now. The European Commission presented its digital Omnibus package in late November 2025. It creates a brand new legal basis for processing biometric data, but only when the person being identified keeps sole control of the verification method. That on-device model is now the compliance benchmark. And defense attorneys in the U.S. are already watching, ready to cite EU enforcement precedents to challenge investigators who can't show documented protocols. So the driving question is simple. Will your evidence survive a courtroom that imports these standards? The first thing worth understanding is what sole control actually means in practice. Under a new Article 9 basis, biometric processing gets a green light only when the data subject, the person whose face or fingerprint it is, retains control of the template and the verification method. Your tool can't just store a faceprint on a server somewhere. The individual has to hold the keys. Both the European Data Protection Board and the European Data Protection Supervisor endorse this approach, which tells you regulatory consensus is already locked in. Template protection and user control aren't aspirational goals anymore. They're non-negotiable. Now, what does that mean for the actual evidence you collect? The package also includes AI development derogations that demand state-of-the-art safeguards. Investigators have to prove their facial comparison workflows prevent unnecessary collection, minimize processing, and actively detect and remove special category data. If your tool produces outputs that get disclosed to third parties without those protections, your evidence could be ruled inadmissible. Courts won't just ask, "Did you get the right face?" They'll ask, "Walk me through your retention policy and bias detection." And how fast will U.S. courts care about a European regulation? Faster than most people expect. The board and supervisor opinions feed directly into trilogue negotiations, the process where the European Parliament and Council finalize the law, likely by mid-next year. Once enforcement actions pile up across EU member states, American Defense Counsel will waive those precedents in front of judges. Any case involving cross-border evidence or a defendant with EU legal representation becomes a flashpoint. Most people assume the biggest risk with facial analysis is a false match. Within 2 years, the bigger risk is that a correct match gets thrown out because you can't document how the biometric template was stored, retained, and audited for bias. So, plain and simple, the EU just rewrote the rules on who controls biometric data and how it's handled. If your facial comparison workflow can't prove compliance with those standards, your evidence is vulnerable. This isn't a 5-year horizon. Adoption is expected by mid-next year, and enforcement is already happening. The investigators who document their protocols now won't be scrambling when a judge asks the hard questions. The written version goes deeper, links below. Now you know something most people in this industry don't. Use it. And when you're ready to put it to work, caricomp.com. We'll see you tomorrow.